Charles Coleman is back with me, but also joining the conversation finally to discuss the second historic indictment of Donald Trump is Bradley Moss, national security attorney. Bradley, we missed you at the beginning, so I want to start with you now. Trump was charged with 31 counts of willful retention of national defense information under the Espionage Act. I, along with others, we've been talking about this. Does Jack Smith have to prove this case? Well, we know he's proving it in front of a jury, but is he able to share these secrets with America?
Not necessarily the public writ large, but the jury, yes, to an extent. So there is a procedure set forth in federal law called the Classified Information Procedures Act. It was designed to address these very types of cases where there's classified information at issue, where the prosecutor has the burden of demonstrating that the documents at issue constitute national defense information. It affords the prosecution various procedures, including closing the courtroom, including providing summaries or stipulations instead of the actual documents, to allow the defense to obviously have access to the relevant information for purposes of due process, to allow the jury to see or understand the information so that the government can still meet its burden while still protecting the due process rights and the constitutional rights of the criminal defendant, in this case, Donald Trump. So there is a way to do this. It's not easy. That's why they're not using all the documents. They've chosen a select group, these 31 particular documents at issue, but there'll be very specific procedures they will go through to ensure that they can present their case without further jeopardizing national security.
Bradley, I want to stay with you for just a second. Concerning these 31 counts 1 through 31, it takes the jury to find that Trump is guilty for only even just one of these counts in order for him to have to do some jail time, right?
Most likely, yes. Now, if it was literally of all these counts, if he just got convicted on one, there's always the possibility that in that case, maybe he would get an extended period of probation or something along those lines. But given the nature of this indictment, given the factual allegations, if the jury is going to convict on at least one, they're likely convicting on multiple counts in this case. They're likely probably going in and convicting him on one of the obstruction elements. So if this goes through the trial, if this results in a conviction, and if there is not a pardon or commutation that gets in the way, it is more than likely he will face some actual jail time from this case.
Charles, we were talking about Aileen Cannon prior to the break. Trump, in typical fashion, already going after Jack Smith, talking about his family. Ken Dilanian, when he started our show, was talking about the possibility of maybe there being some type of conditions imposed on Donald Trump that would prevent him from being able to speak out. I mean, what are the chances, Charles, that a judge like Aileen Cannon is going to muzzle Donald Trump in some way in terms of his ability to continue to spew violent rhetoric against the special counsel, the DOJ, the prosecution?
Well, Katie, that's going to be the first test for everyone who is wondering how impartial this judge will actually be. I do think that you may see some conversation from the DOJ asking for limitations to be placed on Donald Trump in terms of his rhetoric so that the integrity of the case and its prosecution isn't compromised. And how Judge Cannon responds is going to be a key indicator in terms of how she is going to approach dealing with the different things that are going to come up, both evidentiary and otherwise. So people will be watching this to see whether, number one, the DOJ and Jack Smith looks to try to curtail some of the public discourse around this from Donald Trump, and then also, of course, how Judge Cannon responds. It's something that I'm watching because you do not want to run the risk of curtailing a defendant's First Amendment rights any differently than you would in another case, but you also have to be mindful in balancing that this is not any other defendant. You're talking about someone who has an enormous platform and their reach is very, very far and wide, and that could ultimately weigh in on the case in a way that becomes prejudicial, either against the DOJ or ultimately in his favor, one way or the other. And so Judge Cannon's ruling, should this issue come up, which it likely will, is going to be very, very insightful.